All right, just everybody remember to use your mics when you're speaking. Like to call the December Town of Lloyd Zoning Board of Appeals meeting to order. Please rise for the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
The exits are to the rear, both sides. Please turn your cell phones to silent. All right, we'll hold the minutes to approve to the end if no one has any objections. New business, Pepino Foods, 304 Station Road, SBL 86.4-1-22. Commercial area variance. Applicant is seeking area variance from max lot coverage of 10% to actual coverage of 35.3%, 5.9% increase from previously approved site plan, and a determination that the 100-15B11 50-foot buffer setback is adequate to permit the amendment of the applicant's site plan originally approved 32102 to delete the 12 parking spaces on the north side of the building and add 17 parking spaces on the east side of the building.
Okay.
All right, representative from, hello, sir.
Hello, my name is Philip Jampertone, law offices of Lewis and Greer in Poughkeepsie. I represent the applicant. And I think it's helpful just to understand a little history of this particular site. There you go. I think it'd be helpful to understand a little bit of the history of this particular parcel. It's 304 Station Road. If you're familiar with Station Road, the client is Pepino's Foods. It's an old apple cooler that was converted into a warehouse for distribution of food goods to restaurants, Italian restaurants in particular. So the pertinent history is that there's a railroad bed that runs alongside this parcel. The county acquired the former Central New York New England Railroad at a tax sale prior to 1990. And they offered to the adjoining landowners to sell the abandoned rail bed. And what they did was they would sell a parcel the length of your abutting property to the center line of the rail bed. The Ulster County Legislature approved the sale of these various parcels by resolution adopted in March of 1990. And the county attorney drafted deeds, and the deeds were mailed to those adjoining property owners. So at the time, the Ulster County Attorney's Office would mail these deeds. They have since changed that practice, but at the time they mailed them. The deed apparently was not filed, so the transfer was never consummated legally. However, the owner at the time, which was Cornwall Enterprises, subsequently sold the property in 1992 to a company called
The owner of which property? The rail bed?
the adjacent property, 304 Station Road. The deed apparently was lost for that little railroad parcel.
Okay.
So the deed for the main parcel, 304, was transferred from Cornwall to BBM of Milton Incorporated in 92, subsequently transferred to Millbridge Company Incorporated in 95. My client acquired the property in August of 2001. When he acquired the property, there was a dirt parking lot and a dirt driveway on this parcel, the old rail bed, that allowed him access to the east side of the building where the offices are. So in 2002, he got site plan approval to open up his business. I believe he was in front of the ZBA to get a variance because of the use in the agricultural district. And he started using the parking lot. It was a dirt parking lot up until 2008, at which time he blacktopped it. And he continued to use it until approximately last year, when a neighbor complained and the zoning administrator, assistant building inspector came out, pulled out the old folder from 2002 and said, hey, wait a second, there's no parking shown on your original site plan. And we went through everything we had to do to find out that that parcel, the deed was lost. It was conveyed to the prior owner of 304 Station Road, but the deed was never filed. So we've since then formalized the ownership with 304, consolidated it with 304. So to illustrate this, I brought some packets. I apologize, our printer, there was a mix up with the printer, but this will, I brought 5 copies. Nope. Just drag the parts out of question. No, I have one here. Okay, so the first page, the blue parcel shown on the first page is 304 Station Road. The yellow parcel is the strip, that's half of the rail bed that was supposed to be transferred to the blue section. The second page of this handout is from the Ulster County Parcel Viewer. And this is an aerial photograph from 2004. The blue is supposed to be the lot lines, but it's a little bit offset because the viewer is always a little offset from the aerials. But you can see to the right side of the building, you can see the driveway coming in. You can see cars parked there.
That's in 2004.
2004.
Okay.
Okay, the next page is also from Ulster County Parcel Viewer. And you can now see where the parking lot has been blacktopped. And you can see cars in there. So we've been using it, my client's been using it for a long time, until recently when the dispute arose with the neighbor.
Okay.
So we were asked to submit an amended site plan to the planning board showing the additional parking lot. The last page of the pamphlet is the original 2002 approved site plan. And on that site plan, it shows 12 parking spaces here on the north side of the building. So we were advised to submit an application to the planning board to move these 12 spaces over to this new parking lot that we had been using for all these years. And then in that process, the zoning administrator pointed out that there is this section in the zoning code, section 100-15, subsection B, subsection 11, which deals with agricultural buffers. So we would have to come to the ZBA and seek a variance. Now, the particular subsection dealing with agricultural buffers states right in its purpose that it recognizes the potential incompatibility of certain agricultural procedures with residential development. It does mention and other uses, but I believe the legislative intent of the section was for subdivisions, and it spells out subdivisions. They didn't want residential subdivisions next to pesticide sprayers and other agricultural nuisances. This is an old apple cooler warehouse that's used for distribution of food products. It's not a residential use. Also, subsection A says buffers adjacent to actively farmed lands. The apple orchard to our east, who's raising the concern, they've already stated in their letter that they're plowing under their trees, and it's really not an active orchard anymore, that they're plowing under the trees. Their cooler burned down a couple of years ago, the Zimmermans. So I don't believe that the section applies because it's not an actively farmed land anymore. Furthermore, looking down further, it says that if it is an actively farmed land, that this section requires an enhanced side yard setback of at least 50 feet. Now, the buffer it refers to is not defined in the zoning code. There's 80 references to buffer, but there's no definition. And every reference to buffer is in a different application. So there is no definition of what a buffer is. What we do know is it does says an enhanced setback, but there is a defined definition of setback. Setback is defined as the distance in feet between a structure and a property line. And a structure is further defined as a static construction or assembly of materials, the use or occupancy of which requires a fixed location on or under the ground or attachment to an object having such a fixed location. Structure shall include, among other things, buildings, dams, docks, stadiums, sheds, storage bins, reviewing and display stands, platforms, towers, walls, fences, swimming pools, tennis courts, gasoline pumps, billboards, signs. Structure shall not include utility poles, wire, and related equipment. Nowhere in there does it reference parking lots or driveways. And in my experience, I don't know any zoning code that considers a driveway or a parking lot a structure. So consequently, the planning board believes that our application for an amended site plan would violate this section because our parking lot would be within that 50-foot buffer. So we're seeking first an interpretation of the zoning code to see whether or not it even applies, because the violation is that it's a parking lot within this buffer area. And secondly, if it is, we're looking for a variance. If you look at the original site plan, the building originally was 5 feet off the property line. We have now added a 50-foot parking lot. So the edge of the parking lot is 5 feet from the property line. So if we wanted to put in any, we could use that 5 foot as an agricultural buffer, right? Or we could, put in some trees, bushes, whatever the planning board want. But we're hoping that if you interpret that this buffer applies, that you give us a variance from 50 feet down to 5 feet, so we can do whatever landscaping and shielding that the planning board wants in that 5 feet.
Full disclosure, I am related to the apple farm you're talking about.
This is Zimmerman's.
It will not have any bearing on my judgment whatsoever.
Okay,
But I do have a few questions.
okay,
All right, so on your original site plan,
right,
it shows lands of Florence Zimmerman.
correct.
So that 50 feet that you're talking about, your client never laid claim to that 50 feet
Well, here's the
in
thing.
2002, because if they did, they would have put it on their original site.
Well, this is where my client hired somebody. I don't know who, but they didn't do their homework, because had they would have known that Zimmerman didn't own the property. And in fact, I have a memo.
But did your client think that he owned the property?
Yes, my client's not here because he sells cheese and meatballs. He doesn't understand this stuff. So he hired someone to go in, get him site plan. He hired a contractor to build out the building because it was an old abandoned cooler. And then he runs his business. And he believed that he owned that dirt parking lot that's shown in the aerial and that dirt driveway. He believed he owned it. David Rohr across the street told him, oh yeah, you own it because the county sold half of the rail bed to each adjoining landowner. So that's yours. So he believed. The building is, according to my client, I wasn't there. The building inspector parked in that dirt parking lot, came in that dirt driveway to come in and inspect the construction of the offices. So it was his belief that he owned it, despite this piece of paper, which he may have been provided but didn't understand how to read. He claims that he believed that was his, and that's why he's been parking there since he owned it. That's why the building inspector came in that driveway and parked there. And that's why he paved it. And
But
David
there's
Rohr didn't believe either.
But there's documentation that, according to the documentation that's in front of us, he didn't own it, because it clearly states lands of Florence Zimmerman.
Zimmerman never owned the property.
Whether they did or didn't,
That was,
your client, if your client looked at this paper, and I'm assuming he did, because it's his property, it clearly states that that land is someone else's.
if he looked at this and understood what it meant. And I'm not saying, he came from Sicily at the age of 22, and I don't know if he knows how to read a survey or a site plan. I can see that, you can see that. My client claims he didn't look at this. He didn't participate in this. He came up here, moved into the area to open this business.
Did
Hired
he
someone to do this.
understand the site plan as it was issued to him?
I don't believe he participated in the site plan process. I believe he hired someone like I'm here tonight to come and do it for him. So I don't believe he saw this and understood this, as he did not own this land. He was under the understanding that that dirt parking lot alongside his building,
Which is not shown on this map and is
Right,
not in his
because-
site plan.
because what I believe happened, and this is purely speculation, is that the surveyor who prepared this took the deed that he was provided at the closing, which is this parcel, because the parcel in question is a lost deed. So it never belonged to Zimmerman. And in fact, if you pull up this deed reference, deed library 1576, page 333, if you pull that up, yes, that is a Florence Zimmerman deed, but it says right in there that the 100 feet on the western boundary is owned by this New England Railroad. Because
So it's 100 feet, not 50 feet? Because originally you said it was 25 and 25.
oh, I misspoke. It was originally 100. 50 feet goes to each property owner.
Okay, that's not what you had said originally. You said it
I
was 25.
apologize, I misspoke. I didn't realize I misspoke. But it's 100 foot, 50 feet goes to each. That's why we have a 50-foot parking lot there with the 5-foot buffer. Now, if you pull up this deed again, it is in Florence Zimmerman's name, and it describes the metes and bounds of all this property. And then there's a paragraph that says, accepting the lands of the New England Railroad, which is described by a metes and bounds description along the western boundary and being 100-foot wide.
Does your client's deed say the same thing?
My client's deed says it runs along the railroad. So now, in the process of clearing this whole thing up, I did go to the, I had to work with County Real Property, and this is their correction for the tax map. So it says right there that when the mappers originally mapped the tax parcels, they erroneously included that parcel into the Zimmerman property. So when the professional that drafted that original site plan, perhaps they looked at the tax map and just said, oh, the neighboring property is Zimmerman, but they never did the research they're supposed to do. Surveyors are supposed to read the deeds of the neighboring properties and make sure there's no problem with the neighboring property.
They would have a legal action against the person.
We don't want that. And again, we've been using this. My client's been using this for many years. It hasn't been a problem till now.
And I mean, another thing I'm looking at is your original site plan clearly has the parking in the front of the building.
That's where whoever prepared the site plan put those. Problem is the septic's out there. And the other problem is the ADA entrance ramp is in the far bottom corner of the offices.
So this was done fraudulently then.
I'm not saying that. I'm just saying that the septic area is in the front lawn where that parking is. And I'm saying that the ADA entrance, the approved ADA entrance to get into the building is all the way down here at the bottom corner. So the ADA entrance originally, there was a 5-foot from the property line to the building, according to this. There's no ADA spaces denoted, which at the time you had to. And they would have to push a wheelchair down this 5-foot corridor between the property line and the building down to this lower corner. If you look down here at the bottom, that kind of hashed in spot, little rectangle, that's the concrete ramp. That's the ADA access to the building. So in our new proposed site plan, the ADA parking is directly across from that ramp. And in reality, ever since we've owned the building or started using the building in 2002, now the site plan was approved in March of 2000, or February of 2002. By the time the whole thing got built out, we weren't using it until the fall of 2002. But they've been using that parking lot.
But that's where I'm having the problem. Your site plan clearly shows you're parking in one location and you're parking in a completely different location. So you're going directly against the site plan that was approved. Your site plan is right here. It shows parking right here.
It shows it up there, correct?
Okay, but you didn't do that. You parked over here on lands according to the map that you didn't own.
But again, you're assuming that my client looked at this and understood what he was looking at.
That's
What he saw was he came up from the city, he bought this building. As the aerial photograph shows, there's a dirt driveway going in and there's a dirt parking lot. And he pays his attorneys to go to a closing, he buys it. They say you're gonna need a site plan approval. He hires a local professional. That local professional prepared this. And apparently, I wasn't there, but if it's Patty Brooks, she goes to the ZBA for the client. She goes to the planning board meeting for the client and she gets it approved, right? And the client doesn't, I've been to many planning board meetings and she's rarely accompanied by a client that stands up. She takes care of it for them. And I don't believe my client participated in the preparation of this. I don't believe my client
so
participated in the approvals or looked at this and understood this. He saw a dirt driveway and a dirt parking lot.
So by him not participating, that allows him to go against what has been approved by a board because he didn't understand.
No. And as soon, dry mouth with this, as soon as it was brought to his attention by the zoning administrator, we immediately got it surveyed, found out that BBM Incorporated still owned this lot, right? Because it was deeded to them and they never filed the deed, but the county's position is that they sent the deed. So I had to go through a year's worth of legal, process to get it because BBM is disbanded. They're no longer a corporation. So we had to publish it, to the public and see if anybody would lay claim to the property. So we went through the whole legal process and finally the court granted us the deed. We laid it all out in the court papers, the whole history of the parcel. We had affidavits from the county attorney's office that was their standard practice to mail the deeds, that there's documentation that Cornwall Enterprises, the owner of 304 Station Road at the time,
No, you've gone through that.
right, all of
get
that's
that.
been done. Yes,
I get that.
so
I still don't understand how it justifies what happened here.
again, you buy a building, there's a dirt driveway, there's a dirt parking lot. And you assume it's yours.
I wouldn't do that.
Sir, I wouldn't do that, but I'm not my client. Again, he came up, oh, this is a warehouse. I can run my business out of here. What do I got to do, lawyer? Okay, we got to go through this closing, this and that. Why no one ever pointed it out to him? Why no one found this lost deed until just recently when I got involved? I don't know.
So the variances you're looking for, one is lot coverage.
Lot coverage, right, because the original lot coverage, it's hard to say what the original lot coverage was because it really doesn't show the parking. It doesn't demarcate the parking. Now, our new amended site plan, it's all done on CAD. They can calculate it out to the square footage. So
But you exceed with your new you exceed the 10%. You exceed the allowed coverage.
This exceeded the allowed coverage.
Okay,
This exceeded the, if you look at my application, look at the new site plan, the bulk table on the new amended site plan. We already exceeded it and apparently, I'd have to check with Dave, but we must have gotten a variance at the time. I believe we got a use variance because of the use in the agricultural district. But if you look at the new amended site plan, the bulk table, it shows that we exceeded the lot coverage at the time. Now we're further exceeding the limit.
Okay, so one of your variances is you want a variance to go 5.9% over what you already have.
Correct.
The other variance you're seeking, and I guess you're seeking a determination on whether you would need a variance, whether the setback,
Includes the parking lot, or that buffer includes a parking lot. Right, so we're saying the buffer is not defined. Setback clearly doesn't include parking lots. So,
well, you also had brought up a good point, which I didn't really think about until you said it. Apple farmers spray,
correct,
and if they're spraying and there's cars parked 5 feet from where they're spraying,
but if you visit the site, you'll see there's no trees within the,
well, I understand that.
Today it's
I'm not an apple farmer, but I am a farmer.
I understand.
We change our process, rotational grazing. I know apple farmers, what's marketable right now is not marketable 10 years from now.
Right.
Empires used to be the thing. They're no longer. So now it's galas and everything else. So they change their practices, just like a beef farmer changes theirs, or any business has to adapt with the times.
Right.
So just because they may not have trees and are spraying there right now does not mean that they may not in the future. And I don't know. I don't know if they are or not.
Right.
But it is agriculture and they should be afforded that to do on their land. I mean, if they replant, they do trees, your car is parked 5 feet off of where a sprayer is going by, you're getting covered in spray.
If they planted right up to the property line, but if you go visit the property, you'll see that there's a down slope from their property and then about an 8-foot like drop off to where the railroad bed was. They're not going to, it's not flat. They're not planting up to the property line.
Okay.
You really have to visit the site and see. There's actually a natural barrier
Would your
between.
client have an issue if I did go visit the
My
site?
client invites you out there because he's trying to get this resolved. He's just trying to run his business. Go out, see where the parking lot is. And quite honestly, we didn't anticipate this much objection. We understood that, yeah, the site plan was bad. We went in we basically just resurveyed it, went into the planning board, and we've gotten a lot of resistance. And unfortunately, my client, wants to double the size of his warehouse, which I understand now is not going to happen. So his business is booming. He's got 40 local employees and he's renting extra warehouse right now. So he had envisioned going and seeking to double the size of his warehouse. But with the resistance we've got, it doesn't look like, if we can't have a parking lot, you guys aren't going to approve another warehouse.
Never say never. Okay. So is there any other information that the board requires of the applicant? I'd like to see the paper trail of the deed you were talking about.
Sure, I can
How
provide,
that progressed,
absolutely.
and to see
I can,
time-wise where that fell into place, because I mean, the map, this is what I can't get over. The map clearly shows that your property line is 5.31 feet off
off of the parcel, when you like. my
Right,
plan- yeah,
but what you presented
Right.
to this town, to the board, and I don't think I was on the
What my
board then.
client's representative at the time presented to the board.
Right,
What should have been presented to the board at the time was something in line with my handout that showed that separate parcel.
right. And again, it wasn't.
It wasn't. I agree.
This approved parking here, the parking is now over here. I mean, there's
Right.
like some rules that were broken. Right?
I'm not denying that.
Okay.
I'm not, we're seeking, permission to move the parking and document it properly.
Does anyone from the board have anything that they think they need from the
I do.
applicant?
I just want to make sure I'm clear on what we're looking at in these plans. Your first page, this is the parcel that the client owns, the blue and the yellow. Is that correct?
Correct. The yellow is the parcel at issue.
That's about 50 feet wide.
It's 50 feet wide at the length of the blue parcel, which is like 660 feet.
When I flick through these pictures here, I come to the third page. The third page shows me the blue parcel where the
Correct.
building is. It shows me the parcel where the railroad used to be,
Correct.
50 feet. And then beyond that, into the neighboring property, I see parking and cars. That's what you're showing me.
That's what I'm showing you because that's what's on the county website.
Okay.
Because it's really difficult to align the tax map with an aerial photograph. They're flying at 10,000 feet with these aerial photography equipment. They put out all sorts of control marks you ever see on the road, the big white crosses. That's so that when they take the picture, they can kind of line up the crosses from the picture with the crosses on the ground. But it's not perfect. If you go on to the any county parcel viewer in New York State and you pull up an aerial photograph overlaid with the parcel map, it's never going to align perfectly.
Mr. Chairman. Russ, I can answer that real quick. The part of the issue is the projection. So you're familiar with how a map gets projected from the center of the earth?
Right.
The way the photos are taking, as just described, is accurate. They take them from a certain height and angle. The hiccup is the parcel lines themselves are done under a different type of projection. So they never line up. It's
Okay. Well, I'm still
one of the
seeing-
reasons why I'm getting grayer by the day.
I'm still seeing 16 to 20 feet of invasion of the neighbor's.
Yeah,
property.
it's actually,
That's a lot.
yeah, the offset is actually about 40 foot in the northerly foot count and
Okay.
about 30 feet in the easterly foot count.
So that parking lot could be in the,
No, if you look at the proposed amended site plan,
It's right
that's an
behind you.
actual survey. You'll see that the blacktop is
On-
5
right,
feet
it's on
from the
the-
property line.
okay, good.
There is no
All right.
incursion into
So,
the neighbor's
this
property.
is what I have, so.
Right, yeah, it's just,
I need to understand what I'm looking at. Thank
Right.
you.
yeah, the amended site plan actually surveys it out. The blacktop is 5 feet from the property line.
Okay.
Do you show that? Do you show that 5 feet on here?
Is it dimensioned?
Yeah, I don't see a dimension from where the edge of asphalt would be to the property line. I don't see a dimension on that.
The engineer tells me it's 5 feet, but I can
Gonna
have
need
him
to-
dimension it in a,
We're gonna need to see.
okay.
It just can't be what somebody says or whatever. We need
I
that.
understand that. Well, I can make sure that that's a dimension on the drawing. It was on the prior one, showing that the property was 5 feet. Actually, if you look at the original site plan, it's like 5 feet on one corner and 6 feet on
5.31 and 6.8.
6 on the other, right?
Okay, Paul, do you foresee any other information that the applicant needs to provide?
Correct. I can get you a full property history with copies of the affidavits from the county
And a scaled site plan,
and a scaled site plan.
please? Okay, I'd like to entertain a motion to set a public hearing for a January meeting.
So moved.
Bill, second? Russ, all in favor?
Aye.
Aye. Okay,
January 13th. I got one more question.
Sure.
go ahead, Paul.
Proposed parking lot. I'm just looking just for another 5 feet here. Can that black top, can that,
Proposed parking lot.
oh, it's over here now.
Here, Paulie, this is the proposed, I don't think we have it out here, I just got this from, this is the proposed over here, this is the parking lot, this is the property line. This is what they want to give as a buffer rate, but there's no
Okay.
dimension on it.
All right, I wanna, your engineer,
Uh-huh.
I wanna know if he can do a parking lot on 45 feet instead of 50.
The parking lot's been there since 2000.
I
Yeah.
understand
So
that.
you're saying cut 5 feet of the blacktop off? Is that what you're
I'm
proposing?
just looking for.
A
if
larger
it's
buffer?
Possible, instead of having a 5-foot easement.
Have a 10
Have a 10-foot.
Okay.
buffer. I'm just looking to see if it's possible. I'm not
Oh.
telling you what we wanted, but I think that it's something that we consider to look into.
I would rather tear up 5 foot of the parking lot than the whole parking lot.
You brought up a point before that I'm just seeing now. You said that the parking on the original site plan, the parking was over the septic.
Well, to get to the actual parking spot, the septic is out in that grass, yes.
So does the driveway go over the septic?
No, that was an issue that the planning board made us verify. The engineers went out and verified it.
We're gonna need to know exactly what, just dimensional off of the roadway, your driveway, where the septic is.
Okay,
I see it in here, but I see no dimensions for where it is.
Parking lot over here, because,
Well, this is where the parking was supposed to be. This is where it was approved originally.
yeah,
but
but
they
they
put it
said,
over here.
they said the septic is there, that's why.
the septic is in the corner, the tank is in the corner of the building, and then the fields are out in that grass in front on the north side of the building. Right.
Here's the tank.
But the fields are above that driveway as it's drawn.
So, John, can I interrupt real quick?
Okay, and they're there, right? That's existing or that's,
He's saying no, that's my next question. He's
That-
saying, you're saying that they're above that.
right,
Yeah,
sure.
yeah, the septic fields don't go into the driveway.
This is the map that you submitted for the planning board to review, yes?
Yes.
Hmm.
Why? What are you seeing on it that I'm not understanding?
The driveway comes in.
So,
Hold on.
Do we-
Hold on, we gotta- Hold on. Okay, guys, let's have a little show and tell. This is your driveway,
Yes,
this is the septic tank,
yep,
that's a septic tank.
now the little checkered area is your septic field.
No,
Proposed approximate location,
primary and reserve septic area. So where actually
that-
is it?
where is it?
it's above.
On this side?
Yes, it's up in there, yes.
So what was submitted is.
That looks like another, I mean, this has got to go through multiple drafts, but yes.
Okay.
We verified because planning board said, where's the septic? Because you got this driveway coming in. We had to verify where the septic was. The engineer worked with the county, found out where the septic system is. And the driveway does not go over it. I believe what's crosshatched, because you have to have expansion area, right? Unused expansion area.
I get that, but that says approximate location of
Yeah.
primary and reserve septic area. So
Yeah,
you're gonna
that's-
have to tell us
We're gonna get
exactly
we're
where it
gonna
is
get
and
we'll
dimension
get
it.
revised.
Okay.
All right, we can get that. I don't know if I can get that by January, but we're gonna get that.
Okay,
Just
well,
'cause of the
it's a
holiday.
it's a public hearing.
Okay.
You're
Um,
not closing this one.
Thinking there's,
No, this is just
Yeah.
a,
this is just information, preliminary and.
So you want, yeah, there's a lot of problems on this.
I see that. As long as we're
can't
both
go-
on the same page, you got a lot of problems.
well, just try to get this all
Okay.
straightened out.
Yes.
Back to normal.
Right,
Okay.
so we're gonna get the parking lot dimension and we're gonna get the,
Offsets dimensioned,
and the septic.
septic dimensioned,
And I'm-
and the roadway coming in, make sure you have that located with dimensions as well, so we can say exactly where it is in regards to the septic. So
Okay,
we need dimension on everything. We need to
Alright.
know exactly location of everything.
all right.
All right?
Not a problem.
All right,
All right, thank you.
see you in January. Okay. Extended public hearings, ADC Ulster, Falcon Ridge, 301 Upper North Road, 357 Upper North Road, SBL 80.3-1, 18.110, and 80.3-1-31. Appeal. Applicant is seeking an appeal, a determination from the town code enforcement officer about the treatment plant and a portion of the road being in a light industrial zone that are intended to serve single-family residences. Okay. So, oh, sorry, buddy. Sorry, buddy. Did you hear me that time, or you want me to repeat it?
Are you speaking to me, sir?
Okay. For the record, we should take out the treatment plant, right? Okay, so let's take that out. I can do that now, right? Take the treatment plant completely out of all discussion,
Yeah.
right? Okay. All right, so that's gone. Okay, so we have some correspondence with the applicant about this. I unfortunately was not here for the last meeting. I read the minutes. You guys want to expand on your thoughts from the last meeting, or? You gotta turn the mic off. Go ahead.
I thought we were pretty well set on what we would like to do. Is we've got to make a motion to town code enforcer made a decision, and we want to make a vote on how the board feels in that motion. So we have,
Well, do we want to do a draft resolution first? Do a straw poll, do a draft resolution, keep the public hearing open for that. And then we'd be able to vote on the draft resolution at the next meeting.
right, I have no problem with that.
Is that- Okay, so, I mean, I read it, and perhaps the applicant can speak to it a little bit. I see it as fairly black and white. It's a residential use in a light industrial zone, which is not allowed. And speak to it if you can, speaking to the applicant, Mr. Gilchrist, your feelings on it, because I see it as fairly black and white.
Well, I'm happy to. Andy Gilchrist, representing the applicant ADC Ulster. And we have had the opportunity to discuss this with the board at two prior meetings. And I know your counsel has also offered his opinion on this. And as the primary legal proposition, we don't disagree. The issue is an access road, in this case, a proposed public subdivision road, leading off Upper North Road into my client's property, into the R1 residential zoned portion in order to propose and construct a 166 lot subdivision with internal public subdivision roads being proposed. The difficulty, of course, arises from the entire frontage for my client's property is along Upper North Road. There is no other available public road frontage for this 520 acres. What the town has done through its zoning is bisected my client's property between two zoning districts. The bulk of the property is zoned R1 residential, and that's the project that's being proposed. But the entirety of the access has been zoned light industrial. It, in essence, creates a gateway into the balance of the property. And the legal proposition of, well, the subdivision roadway is characterized as residential, and residential is not allowed in the light industrial zone. If that is in fact upheld, the property, for the very purpose it's zoned for, R1 residential, cannot legally then be developed. We view this as, while the primary legal proposition is the access road, the land use to which the access road leads must likewise be allowable over the entire length of the access road, as having a very important exception under the law, which is if that is the only available means of access to a public roadway, then that general proposition must yield, and the property owner must be provided access to the public road. Your counsel does not view that exception as we do, but we think it's very clear under the law that when the land is otherwise landlocked and a use that's allowable by the town, here the R1 zoned property, cannot be used because you cannot get out to a public roadway, that again, the main legal point yields to the exception. And we think that that's our case here. We do think the zoning determination should be overturned because otherwise the property does become landlocked and cannot be used for the R1 zoning uses. So we have submitted our legal position on that, including some case law in New York that speaks to this fact pattern. This is a fairly unique situation. It's a very large parcel of property. The vast majority of the town has determined is appropriate from a zoning perspective for residential development. Yet the way that the zoning law has been interpreted blocks that development because it blocks the access.
Okay, but on the determination itself, just on the face, it's not an allowed use in the zone. You can absolutely go for a variance, which you are doing.
Mhm.
But the determination, in my eyes, is correct because you want to put a residential use in a light industrial zone. So the building inspector, and this is my opinion, he can't change what the law is. Right? I mean,
My response is, on the face of the zoning law, there's clearly allowable uses in the R1 zoning district, and there are allowable uses in the LI district. No one disputes that. You can take a look at your use table and see those. The concept we have here, though, about the access road, the use to which the access road leads must be allowed during all districts over which the access road traverses. That's not stated in your zoning law. That's actually stated in case law in New York. And that's what the building department has applied in its interpretation. But there's also an exception in case law in New York regarding an otherwise landlocked piece of property and having the zoning code and apply in a way that does not allow the property from a zoning perspective to be used. And so while the case law has been looked at by the building department to support its determination, we've submitted case law that also describes the exception to that rule. And we're hopeful that the board considers that exception in rendering its determination. There's nowhere in your zoning law that states the end use to which an access road leads must be allowable over the entire length of that access road. That's not in your code. That's in case law, and the exception to that general rule is likewise in case law. And that's what we presented, and we know that your counsel has an opportunity to review that and render his opinion, and the board can be guided. But certainly our position as a matter of law under the applicable cases is the town of Lloyd zoning law cannot be applied in a constitutional manner the way the building department has interpreted and sought to apply it. So we hope the board considers that. And we are very grateful to have the alternate relief of applying for the use variance, and we're prepared to present that momentarily, but just on the interpretation, we think the law does support our position.
thank you.
Thank you.
Okay, so you guys have kind of heard everything.
I'd like to make a point. I'd like to make a point. You mentioned that your client had a piece of landlocked property and the light industrial blocking it. If he knew that at the time that he bought the property, why wouldn't he have pursued looking into the possibility of having access at that time?
Well, again, I think any property owner has the right to take a look at what the access to its property is and what the applicable law is. Meaning, even though the zoning map and the zoning code shows that light industrial, I don't think anyone would take that as a conclusion that even though the vast majority of the property the town has zoned R1, that I can't use my property for an R1 use the way it's laid out. Meaning my only frontage is along Upper North Road. It's about 520 acres. The town has determined that the vast majority of it should be put to a residential use, but at the same time has told me I can't get a public subdivision road into my property to develop it in the way that the town has zoned it. I don't think any property owner would think that that would be the conclusion. I'm able to rely on what the law in New York is. And again, what the law in New York is in this unique situation where the only frontage is been split. This is a unique situation where the town has taken a single parcel. Technically, we have two parcels here, 515 acres and 5. But if we view this, what I'm about to say applies to both parcels. It's 520 acres, but the town has split those parcels between two zoning districts. That's fairly unusual. Many times, zoning district boundary lines will follow property lines, but the town has elected not to do this in this case. They've taken the entire frontage of my client's parcel and split it between two zoning districts. It's determined from a zoning perspective that the vast majority of the property is appropriate for residential use, but by placing the entire frontage in a light industrial zoning district and interpreted the law the way the building department has told my client, but you can't develop it. From a zoning perspective, you can't develop it for the very use for the district in which we placed your property. It's a conundrum. I don't care, quite frankly, if the zoning map had said that when my client purchased the property. He's able to rely on the existing law in New York and basic constitutional principles. So I don't think there's an obligation on the part of my client to go out and try to find other frontage when his property rights do include the frontage on Upper North.
How is your client gonna handle the endangered? How is your client gonna handle the endangered species that exists?
Well, Bill, we're not, we're just doing a determination, that's for something later. This is just to determine the building inspector's interpretation of the law. That's all this is right now. Then when we go to the variance, that's when we get more involved. Paul, do you have anything?
My feeling is that we should just vote on what is discussed with the understanding that we'll take in his consideration of getting a use variance. We don't want him, he has a hardship and we
Right,
want to go
but
do
again-
one step at a time.
No, you're right. You're absolutely right. And that's why he has a use variance in front of the board. But this discussion right now is just about the determination of the building inspector's interpretation of the law.
I'd like to make a
So
motion
that-
right now to
You don't want to make a
approve
motion.
make the resolution.
No. What we want to do is we want to do a straw poll.
All right.
Then we want to have a draft resolution drafted, and then we'd vote on that. All right?
And
So-
Mr. Chairman, if I may,
Yes.
you
please.
may want to see if there's anyone from the public who wants to weigh in,
Right.
and then we can, if you
Right, because
want, you
the
could
public
close the
hearing is
public
still
hearing.
open when we're gonna keep it open. Do you guys have any more
I don't.
concerns, questions about this issue for the applicant or council?
I don't see where the Constitution comes in.
Right.
The Fifth Amendment of the Constitution prevents taking by the government without just compensation. The applicant's position is, and Paul can speak to this much better than I can, the applicant's position is if they can't have access to the property, it acts as if the government acted to forbid them from achieving some value on the property, some use of the property that gives them value, and that would act like a taking under the Fifth Amendment. Is that close, Andy?
David is, but we're not quite there yet because we're at the interpretation stage. There is a way that the town can address that through a variance, but Dave, in essence, that summarizes the constitutional point.
And essentially what we talked about last month was in terms of looking at the case law, we don't believe that the town's zoning deprives the applicant access to the public road, just not for the purposes that would like that to be able to obtain access. And then secondly, the whole question about the constitutionality of the application of the zoning code to the property. That's really something that we would say or suggest is beyond the scope of the
this board.
ZBA's purview. Your role is to interpret the law as it exists. A court would
Right.
need to weigh in on the constitutionality.
Okay. Does any member of the public wish to be heard on the interpretation of the building inspector? Not the use variance, just the interpretation. Okay. We're going to keep the public hearing open. But right now, we're just going to do a straw poll, how you guys feel to uphold the building inspector's determination that it's an illegal use in a light industrial zone. Russ?
I uphold the town's code enforcement officer.
Okay. Same for me, Paul?
Same.
Okay. So Paul, could you draft a resolution that we can pick apart maybe and vote on, if you can get it out to us before the next meeting so we can, go over it, pick it apart and come up with anything?
Yep.
All right. Thank you. Okay. So next order of business. All right. This is public hearing, ADC Ulster Falcon Ridge, 301 Upper North Road, 357 Upper North Road, SBL 80.3-1-18.110 and 80.3-1-31 use variance. Applicant is seeking a use variance to create a road in LI zone. I think you guys are all familiar with this because we just went over it. Okay, so there's been a lot of correspondence, both from our council and Mr. Gilchrist. Are you guys familiar? You just have to get, I gotta get my notes together here because. All right, so part of our use variance is competent financial return or financial return, which I believe we got today. I didn't really get a chance to review it at any length because we just got that today, but I think the applicant did provide an actual dollars and cents. Right, I just didn't get a chance. I got it kind of late, so I didn't really get a chance to review it. I apologize.
Mr. Chairman, So they did, in their previous submission, they addressed all the criteria for a use variance. And they have provided, I believe, 2 supplemental letters, one in September, and then this one just in the last 24 hours to further build on their rationale for a use
For
variance.
hardship, for a hardship for economic return.
Yep.
Okay, the first one was a little vague, but the second one I'm thinking is more in
Very
depth.
much on point to
Okay.
2 of the criteria for a use variance.
Okay. All right, whether hardship is unique to the applicant requires a hardship condition not to be found. For other parcels and lines, there would be. So if we grant, because the variance is actually for, it's not for the residential, it's for the light industrial.
Correct.
So if we grant a residential use through a light industrial zone, does it change the characteristic of the light industrial zone?
And that is one of the criteria.
Right,
Yep,
that's.
Yep.
So,
Do you want to, I'm sorry, but I may have missed it. Did you do a motion to open the public hearing? Do you want to give the applicant a chance to
oh, I
present?
did not. Yep, you're correct. I'd like to entertain a motion to open the public hearing. All right. Russ, Bill, all in favor? Aye. Good catch, Paul. I missed that one. Um,
There's a lot of moving parts with this one,
yeah,
so
this is,
Mr. Gilchrist will set us straight, though.
yes. Mr. Gilchrist, would you like to present to the board?
I would, thank you, and we'll work through this, Paul. So in the event that the board does uphold the zoning conformance determination of the building department for the project, then in order to construct the public subdivision road through the light industrial district, we presented the use variance because under the zoning conformance determination, the property could not be developed for a residential subdivision within the R1 zoning district, and this does present a hardship for the property owner. As I said previously, the vast majority of this acreage, 520 acres, has been determined by the town to be appropriate for residential development, and they placed it in the R1 zoning district. Without the ability to plan for, design, and then construct and ultimately dedicate the 2 proposed subdivision roadways as public roadways leading into the R1 portion of the property would create a substantial hardship. And so there are those factors that the board would consider in determining whether a hardship does exist that would support the grant of the use variance to allow the construction of the 2 proposed public subdivision roadways. And so as you just started to mention, the first one is what is traditionally known as the dollars and cents or the economic proof. Absent the variance, would there be an economic hardship? And that's usually addressed by whether the property owner could realize a reasonable economic return for any uses allowable for the property under the zoning law. This is a very unique situation because we've got a parcel that's split between 2 zoning districts. And we would then presumably have a zoning conformance determination that said the use to which the subdivision or to which the access road leads must be an allowable use over the entire length of that roadway. So in our case, if the access roadway comes off Upper North into my client's property, but it's going through 2 separate zoning districts, the necessary result of the zoning conformance determination is the only uses that the property could be put legally are those limited uses that are allowable in both the residential R1 zoning district and the light industrial district. We know that the R1 property could not be used for a light industrial district. That we know from the use table. We also know from the zoning conformance determination, if upheld, the light industrial district cannot be used for residential purposes or subdivision purposes, if you will. So we've looked at the use table under the zoning law and tried to find those uses that are allowable in both the R1 and the light industrial zoning district, because that's the touchstone of what the property, what the 520 acres could be used for. And the only uses that are allowable in both districts are basically conservation and open space. So under your use table, those uses are limited to a conservation area, which the Lloyd zoning law does define as keeping the property basically in its natural state undeveloped. A wildlife refuge, now that's not defined in the Lloyd zoning law, but in general, a refuge is a place of safety or shelter, and it's a place designed to provide a safe haven for wildlife kept in its natural state. Or it can be used for a public recreation purpose. There is also a utility use, but that is limited to an underground utility with an above ground building no more than 100 cubic feet and no other structure. It's basically, if you had to put in an underground utility, water sewer line, that would be allowable. So really what we're left with are, if the zoning conformance determination is upheld, the only uses allowed for this property, the 520 acres, as zoned by the town, are the conservation area, wildlife refuge, or public recreation. So what we then had is our appraisal consultant take a look at large lot acreage that has been sold in the relevant market in the recent years, over the past few years, for purposes of open space and recreation. And that's the information we've submitted to you. And our appraisal consultant went through and created a range of values on a per lot, or strike that, on a per acre basis. We've presented that information to you. We've applied that per acre return for large lot open space conservation purposes in the relevant market. And with the investment my clients made in the property to date, that return actually results in a substantial net negative return on investment for the property. There is no use allowable under the zoning law as interpreted and applied by the building department. And if upheld by this board, that would allow my client a reasonable economic return. Again, those uses being limited to basically, as applied by the building department, an open space or conservation use. So as to that factor for the board to consider, we have presented competent economic proof, the traditional dollars and cents proof, that shows a reasonable economic return cannot be achieved for any of the uses that would be allowed under the town of Lloyd zoning law for the property as interpreted and applied by the building department. It's a somewhat unique situation given the size of the parcel, its limited frontage, and the fact that the town has split the parcel between two zoning districts. Now, a second factor that the board looks at is the hardship unique? And in this case, it absolutely is. We've got a 520 acre parcel where the only frontage for the property is on Upper North Road, and yet the entirety of that frontage has been placed in a light industrial district, creating a gateway into the balance of the property that the town's determined is appropriate for residential development. When looking at the zoning map in the town of Lloyd, we certainly could not find any other situation where that kind of property zoned residentially had been cut off from access to a public road by being split between zoning districts, and certainly not a situation where the size of the parcel at issue is unique as well. So this is a somewhat unique situation where a very large lot has been bisected simply by a zoning district boundary line. So this is a somewhat unique situation. I know I've never run across anything like this in this kind of size and this kind of proposal before. But again, our review of the zoning map shows that it is a unique situation. Then we come to the factor of whether the use would change the essential character of the neighborhood of the zoning district. You know, your counsel said a moment ago, one factor is to consider is this would be a residential use in a light industrial district. But you can't look at this as if the use is going to be residential. There's no homes being proposed within the light industrial district. There's no accessory structures. The only thing that's being proposed within the light industrial district is what would be a public road, a town road, leading into a R1 zoned residential subdivision. It's been designed so that there is adequate buffer between where the road is and where my client's lot line is. The road is not being proposed to be directly adjacent to a property line or close to adjacent properties or any other use there. And so I think it's an error to look at this as simply a residential use in a light industrial district. You've got to look at what's actually being proposed, and that is a public road, a fairly short leg of a proposed public road that'll be designed, constructed according to the town road specifications and dedicated to the town as a public roadway as part and parcel of the residential subdivision. Important to note that while initially the plat did show the proposed wastewater treatment plant being located in the LI district, that would have been a structure. That's been, we've indicated to the board that plat will be amended and the wastewater treatment plant will be fully located within the R1 zoning district to be consistent with that residential use. The only thing left being proposed in the LI district are two fairly short legs of subdivision roads designed to be ultimately public roadways. So this will not change the character of that LI district. It's just a roadway. There already is an adjacent roadway on the LI district. It's called Upper North Road. This would not change the character of that area. And again, we're not here to talk about the 166 lot subdivision. That's a planning board matter, and any issues associated with potential impacts associated with the 166 lots is a planning board function. We're here solely on the issue of the use variance and the very short portion, the legs of this access road that would become a public roadway. And again, if the board were inclined to grant the use variance, you're not approving the road. You're simply approving a use subject under your zoning that would still require review and approval by the planning board. That's an important factor as well. We're not here asking for approval of the road. We're asking here for a use variance that allows the project review to proceed in front of the planning board. And then lastly, the fact.
Excuse me, Andy,
Yeah.
just for a second.
Sure.
Just to clarify, I concur with that analysis, and I think that's the question you were getting at, John.
Right.
We're just concerned about the impacts in the
On
low
on
and
on the
light industrial. Yeah, I
Nothing
was
to do
not
with
making,
with the
right,
residential. Their variance is just for the light industrial. They want a
Correct.
variance for the light industrial, nothing to do with the residential,
Right.
just the light industrial.
right. So you're looking at,
Right.
as Mr. Gilchrist explained, the change to the essential character of the light industrial from having a road go through to the residential area.
Correct.
Sorry.
Thank you, Paul. And then the last factor to consider is whether the hardship's been self-created. There was a question earlier about, well, was the zoning this way when ADC Ulster acquired the property? I've addressed that earlier. I'll address it very briefly again, which is yes. The building department, Dave, has confirmed there's been no change to the zoning map or the zoning districts since 2006. But again, the property owner is allowed to rely on what we feel is applicable New York law on how the zoning would work and how access to a public road would work. I think it's appropriate to look at this as the hardship has been created by the town itself by bisecting this one parcel between two separate zoning districts. Legally, it's supportable to split a parcel between two zoning districts. I don't dispute that. It doesn't happen often, but it can happen. I have had the opportunity to litigate cases dealing with split parcels. It becomes a practical matter about exactly where the lot line is if it's not a certain number of feet off the road. But it is legally supportable to split a parcel between two separate zoning districts. But by doing that, you can create hardships. And this is one because of the frontage issue that has created the hardship. The town has opted, and I think appropriately, to place the vast majority of this property in the R1 zoning district for residential use. That's a zoning determination the town's already made that that residential use is appropriate for the vast majority of this parcel. But by bisecting it and eliminating, or strike that, at least placing the entire road frontage for the parcel in a separate zoning district, light industrial, it's created the hardship of how am I able to get into my property to develop it residentially in a way that the town has said is appropriate from a zoning standpoint. It's the zoning code in this case that's created the hardship for my client. So when we look at those factors, failure to get any reasonable economic return for the uses allowable for this property under the Lloyd zoning law as interpreted by the building department, that this situation really is unique. That a public subdivision roadway, a public roadway in that location through the LI zoning district will not change the character of that LI zoning district. And that the hardship here has not been self-created, but rather created through the zoning plan as prepared by the town and as applied in this case, does support the conclusion that there is a hardship in this case that does support the grant of a use variance. And again, in the event the board does determine a use variance is appropriate, you can certainly grant. In general, you can grant with conditions. You even have the discretion to deny. But even if you do grant the use variance, again, this doesn't approve the construction of anything. It doesn't approve the roadway. It simply approves the use, meaning it would be zoning compliant and the applicant could proceed with his full subdivision review in front of the planning board, including the roadways. And so on that, I'll rest. We think the record does support the grant of a use variance in this very unique situation. And we're available if the board has any questions.
Thank you. Does any board member have anything to add, any question, concern? Okay, I'd like to open it to the public. Does any member of the public wish to be heard? For, against, comments, concerns?
Hi, can you hear me?
Yes, yes, we can.
Hi, it's Kathy. Hi, it's Kathy Hobbs. I own RTH Realty Holdings LLC, which is building which will be building a 12,000 square foot warehouse at 323 Upper North Road. I just want to make sure that any variance for this property would not impact my ability to build what I was going to build in a light industrial zone, which is currently what my land is zoned for.
So if what you want to build is allowed in a light industrial zone, it'll have no effect on what you want to build.
That's all I wanted to know. Thank you so much.
Okay. Anybody? I keep forgetting about that thing. Mark.
Yeah, a quick question on the first part where you're waiting to next month to talk about the first part. The second part, does that also have to wait until you figure out the first part?
Yes, yes, it does. It absolutely does.
So you cannot necessarily make a decision on the second part tonight.
That's correct.
Okay,
That's correct.
thanks.
So nobody else from Zoom? Okay. All right. Sorry, Dave. Does any other member of the public wish to be heard, either live or on Zoom? Okay, I'd like to keep the public hearing open.
Mr. Chairman?
yeah.
Just one thing, and I haven't had an opportunity to look at what Mr. Gilchrist submitted today relative to self-created hardship. But one of the points that I think is interesting is what the reasonable expectation of the law would have been when they purchased the property in 2006. Looking at the zoning code, it's, I don't think it's necessarily determinative in my thinking offhand. But as Mr. Gilchrist pointed out, we're looking at a case determination that has clarified the fact that this would be a prohibited use. Okay, and that determination was made in 2013 by a New York State appellate court.
Okay, and this was purchased in 2006. correct?
Is that correct? And Andy?
Mr. Geltrude?
Yes, property was purchased in 2006, correct?
So I just think those are, important as the board is considering all the different aspects of that criteria. Just keeping in mind those facts, what was the reasonable expectation of the landowner at the time? How clear was the code at that time? It was clarified obviously by an appellate court, but it was 7 years after they purchased the property.
And Dave actually got me a copy of that code. So if you guys want to see this, I'll make copies of it for you guys. This is the code as it existed when the applicant purchased the property. Okay, so Mark again?
One last question. In Mr. Gilchrist's letter, when he talked about this compensation monetary issue, did he supply in that letter, are there amounts of money should go against him?
Honestly, Mark, I got it today.
Okay.
I very briefly looked over it. I believe he gave monetary value, but I didn't look at it closely enough to give you an honest answer. I just got it this afternoon and I did what I had to do and came here. So
If I can, I apologize for it being submitted just within the last few days, but attached to it was, we did have Empire State Appraisal Consultants go through land transfers, basically from 2020 onward. And it identifies the parcels, the town, it identifies the sales price, the total acreage, and as well as a per acre price. So that economic proof on these types of large lot sales for conservation and open space purposes, that's in Empire State's report. Okay.
so does that answer it, Mark? He did. I just didn't get a chance to look at it.
That's the building department, get a copy. Thank you.
Okay, all right. So I'd like to leave this open. Well, we have to leave it open until next month. Got a lot to look at. Everybody good with that? All right. Paul?
No problem.
Okay. Thank you, Mr. Gilchrist.
Thank you, board, for your consideration. Can I just confirm the date of your January meeting?
13th. January
you.
13th. You know what, and rather than copy this, we'll just ship it out on an email, all right? The old code. Oh, committee agenda. Thank you, sir. All right. 180 South Street, LLC, 180 South Street, 87.3-5-14. Commercial area variance. Applicant is seeking an area variance for a side yard setback, total side yard setback, and minimum parking. And we did not set a public hearing on this, correct? This is still informational. We have not set a public.
Yes, we opened it.
We-
Okay.
Okay, we did set a public hearing on this? Okay. Entertain a motion to open a public hearing? Bill, Russ, all in favor? All right, I don't think the applicant was here. We were at Zoom.
Oh, that's right.
Okay, so just refresh our memory.
Sure.
What you're proposing to do.
Thank you. Good evening, Chair, members of the board. My name is Brian Sipperly with Verity Engineering. We represent the applicant and the owners for the project at 180 South Street. Those entities are Matson Consulting and Construction and DJ Direct. Principals of both of those entities are with us in the audience this evening. If we were to refresh everyone's memory, this project was first presented to the ZBA at the August 12th meeting of this year. We had a preliminary project discussion with the board. We received some general comments and feedback, in which case the board then scheduled the public hearing for us to reappear in September of 2021. A week later, after the zoning board meeting, we were scheduled to appear on the planning board meeting. That meeting went generally as did the ZBA, where we were really allowed to only introduce the project at a high level. The town designated engineer is engaged. We received some high-level comments back from that engineering firm. And clearly that board wasn't able to take any action at that time, as the plan in front of them was subsequent needing a few variances to let that plan move forward. So they just generally heard us and tabled the meeting until such time the zoning board could take action. In a nutshell, some of the overlapping comments from planning and zoning were the amount of parking. There were some separate comments that each board had, but some of the overlapping comments were parking. Subject to the planning board comments, the TDE comments, and some of the comments we heard from this board, we do have another updated plan that's right there in front of you. That's a little bit different from the prior plan. Doesn't stress the uses that we described to the board last time. It just addresses some of the deficiencies that existed at the last time. So we're really back again. The delay was commensurate to some discussions that the ownership group and one of the neighboring entities have had. And just due to scheduling and holidays, ultimately the two of those entities had a chance to talk, and they've talked. And so we wanted to get back on with the advancing the project with the town of Lloyd here. So we are back. We are still requesting the same 3 variances as we had previously asked for before. And I'll just remind the board what those were. One was for a relief to the side yard setback. Minimum required is 35 feet. And we are providing 26.7. So that would be a relief of 8.3 feet to the code. The second variance that we're seeking is a relief to the total side yard setback, being 100 feet required. The proposed plan provides 93.1, which is a delta of 6.9 feet of relief. The previous plan that the board saw in August provided 31 parking spaces. The zoning code for the development plan on the screen requires 69 spaces. One of the things that we've done, if I can just get up and point here, we were able to add this bank of 20 parking spaces along with a shuttle bus / bus turnout area, as we indicated that this applicant manages their employee base a little bit differently. They actually wind up shuttling employees to and from local communities in and around the area. So we wanted a place for those buses to reside somewhere on site that did not interrupt the flow of movement of trucks around the site. With that said, I'll just talk a little bit about, I'll spend a couple of minutes talking about the site itself, the existing conditions, just to refresh the board. Talk for a couple more minutes about what the proposal is in front of the board. talk about the variances, and then I'll turn it back over to the board to, for any comments and questions and continue with the public hearing. Is that acceptable?
Certainly.
So again, we have the site itself is 180 South Street. It is located also on County Route 22, jurisdictional to the county. It is principally developed with an 87,000 square foot structure today. What appears to be an amalgam of 8 building additions to date. The size of the parcel, 6.5 acres. And roughly 620 feet of frontage along County Route 22. The zoning is agricultural, and the use being warehouse is an allowed use in the zone. Topography on the site is gently sloping from west to east or from South Street towards the creek, which is the Black Creek, by the way. Obviously, site vegetation is minimal. A lot of the site today is presently taken up with lot and building coverage. We've got a woodline and riparian buffer. We've got the woodline buffer a little bit along the north side and the riparian woodline to the Black Creek along the east. Wetlands, we do have wetlands on the site. They might have been a comment from the zoning or planning board, but these were delineated recently. This is an update. This proposed plan is on top of an updated boundary and topographic survey. But the wetlands indicated here are going to be probably not too evident, but they're generally right along the riparian bank of the Black Creek. And none of this grading or proposed grading or development is planned to encroach on those environmental resources. Site access today is presently served by 2 curb cuts on CR 22, one on the north, one on the south. This development plan does not change site access the way it presently is. Utilities at the site are served by an on-site water well, which is at the north east corner of the building area. It has, I'll call it an on-site, but an off-site wastewater treatment facility. Just to note the board. Off the plan, there are meets and bounds, with the dominant tenant being 180 South Street. The current owner is Charles Andola. It was created at such time that this was sold prior to our client owning it, but this was generally set up as an easement. And the owner of that easement or that property is not interested at all. We don't have a need to purchase it. We don't want to move it. We're not going to expand. It just kind of makes sense to potentially have and take title with the dominant tenant having to be 180 South Street in perpetuity for the sanitary system. But that's just where how sanitary effluent is treated today and will continue to be treated. The site is not encumbered by any easements or anything that we need to be of concern for development. And just from an abutter perspective, we've got clearly the Black Creek running. We share a property line boundary with the Black Creek. Along the south, we've got the septic system and lands of Charles Andola. To the west, we've got a commercial building, and to the east, we've also got the golf course as well. The proposal in front of the board here is to construct a 30,600 square foot building addition that would incorporate 5 loading docks. Those building additions would take place in 3 phases in 3 different parts of the site. One would be loading docks, called the north of the northwest corner of the building. The hatching area here is, there's no building today, so that would be building. And the third, loading docks in the back addition. In general, I think the theme is closing out the building, boxing it in, if you will. This structure, as I noted, is really an amalgam of a number of different building additions with numerous finished floor heights in the inside. Probably pieced together over time to be used and operated as the current owner of the time needed it. There was a tenant between Andola, a couple of tenants between Andola and DJ Direct. And, you know, the building's use and multiple tenants that it worked. However, for a single tenancy, using it as the allowed use of warehouse, it isn't the most efficient layout of a building for the safe and efficient movement of goods and services within a building, okay, especially with the multiple finished floors. In addition to that, it's a very inefficient building to heat and cool and operate. Given the additions that happened at various times, we've got technologies of HVAC equipment and other things that are of different vintages. And while doors are opened up on the inside, it's very difficult for these things to play well together. So in addition to that, the applicant has prepared some site renderings I'd like to share with the board just to indicate what the aesthetics of the project are going to look like. Clearly, that would incorporate a reskinning of the building, inclusion of a parapet roof, redesigned all mechanicals for HVAC, and it'd be a much cleaner new roof line in a much more aesthetically pleasing building when done. I do want to communicate that in general, as the board is certainly well aware, these type of capital investments, need ROI. And generally speaking, the reskinning of the building is an added expense on top of what the applicants would like to do on the inside of the building. Raise the roof line, make it more uniform, some heavy deconstruction and reconstruction within the building to unify the finished floors as much as possible. There will still be 2 finished floors. There's certainly constraints within this structure that would preclude it from going to 1 solid finished floor, but that's what the applicant is really seeking to do with this. If I can, Chairman, I'll just present some of these. I got a packet for each of the board members to look at.
With the renderings,
think I
yeah,
sent it,
I
yeah.
believe we all saw them on email.
You saw them? Okay, great. I didn't know if the board wanted to see them.
You guys saw it on email, the renderings.
You did? Yeah, let me. Get into it. Those about 8 renderings here. Different building angles to help give the board a good understanding of what the applicant is going for.
Thank you.
So that's what we're doing with the building. Again, the 5 loading docks would be appended off the south end of the structure. There are no changes proposed for the utilities. So this type of building modifications do not require, there's one change, but it's generally speaking going to be to include fire suppression. Okay, so that will be done through a series of water wells and storage tanks and pumps. Okay.
Would that be more coverage?
I can get to your question. I heard there was maybe another question too.
Excuse me. You might go on. If you have storage tanks on the property, would be more land coverage.
They'll most likely be underground. They're or interior. So as it relates to the purview of this board, I'm only describing to this board
Okay.
what is
Okay.
going to be going on from a scope of work for the project. And although not shown planimetrically, clearly the design of fire suppression would be something chronologically we would do once the project was able to advance to the planning stage.
So I got another question. In your development, after the fact, you would never go to outside storage. You're saying you will never go to outside storage for a water tank?
I can't indicate to this board at this juncture how the technology will be implemented,
Okay,
whether it be an
excuse me,
underground storage.
where I'm
tank.
going
Yep.
is that we don't want you to come back here and say that we need another 1,000 square feet or 2,000 square feet for storage tank outside the building. We like to know upfront exactly what's going on land coverage.
Understood the question. Thank you. Very good question.
All right, thank
I
you.
think what we would ultimately do at this juncture would be to work around what we have in the envelope and not come back to the board for something so trivial. We wouldn't want to have the tail wag the dog like that, for sure. Understood.
Understood?
Thank you.
Thank you.
I have a few things.
Sure.
One, I'd like to see a current site plan.
We have that. Yeah, you mean an as-built condition survey?
Yes.
Yep, we have that. It was with the original submission, but I do have it. If I could, I have one copy with me. If I can give it to the board, you guys can pass it
Yeah.
around. Fair enough.
Because I'm seeing just a few things that I think we're missing here. I know the last time you were here, we had talked about, we needed to see documentation for the easement for,
It's the third page. Okay, so this is the as-built survey that was recently done. I passed that through.
Okay.
Carry on with your question.
we need to see documentation as far as the use agreement for the effluent for the building. We asked that you provide that at the last meeting. Another thing we had discussed is tentatively removing one of the loading bays, so you would not need a variance. Did you present anything in that regard?
We do not have a copy of the easement tonight for the board to review. Is that a concern of the zoning board of the 180 South Street's ability and land rights as the dominant tenant to use that septic system? Is that?
It is.
It is.
It is.
Okay. I don't think it's something that would be difficult. I believe the ownership is here. Is that something we can get the board?
Okay, thank you.
I will confirm it is a deeded access or a deeded easement for the use of that.
Okay.
I think I've seen that, but we'll get that to the board.
All right,
I
and
can-
again, we had discussed removing one bay, one loading dock to get you into conformity. Have you done anything with that? Have you?
I will agree revisiting these notes from our August meeting. You are regurgitating some of the same things I've had written down. And clearly this proposal that the board is looking at right now still incorporates the 5 docks. The ownership group feels that those 5 docks are needed for the operation of their business.
Okay. I'm also not seeing you're increasing your building, your build out, but you're not asking for a variance. I believe a variance would be required. Am I correct, Paul?
For the building coverage,
Yes.
Mm.
Well, no,
We-
not lot coverage, just building coverage.
right? if-
Lot coverage it falls under something else, but the
Right, the-
footprint of the building is expanding.
The existing building coverage or the standard is 8%, I believe, right?
And
It's 8 and 10. Building is 8, lot coverage is 10.
Right.
The boards.
And what do you have for your building coverage now?
So we're gonna guide ourselves to the bottom of this box.
Mhm.
The existing is 30.69 compared to the 8.
So you're non-conforming.
Today it's non-conforming. The proposed building will be 41% versus the current 30.7.
So that would require a variance for
Right.
that 3%.
Okay.
But to your point, Chair, we did discuss this at the last meeting. In transparency in our request to the town originally, we had determined as the applicant's agent that 5 variances were needed. The 2 additional ones, in addition to what we're discussing tonight, were lot coverage and building coverage. However, Mr. Barton felt at the time those 2 others weren't required. So generally speaking, I'm not in the middle of that, right? It's really, we haven't fought it. I didn't fight him to please add the 2 back on again, but clearly I let the
Well, we-
board talk
we can
about that with
discuss
the
that.
building department, sure.
All right. Okay, with regards to truck traffic. What would you say right now? How many trucks go in and out of here every day?
Yeah,
Certainly. You just got to give me your name and.
Come on up and just give your name on record here in the
My
audience.
name is Ruben Wurzberger. I am the CEO of DJ Direct. Currently, we have anywhere between 5 to 20 trailers per day.
Between 5
To 20 trailers per day.
and 20 trailers.
With the proposed changes, we don't see any increase in trailers. We just want to make it
So
easy.
you can do 5 to 20 trailers with the 2 docks that are there right now.
It's challenging and the trailers idling and waiting one for another. And, you know, it's taking a lot more time to unload and offload. You know, and we've had to push stuff and work overtime and start early.
Well, when you say overtime, what are your hours of operation?
Our hours of operation officially are 8 to 5. 8 a.m. to 5 a.m. to 5 p.m.
Okay.
But, you know, we do start many days at 7 o'clock. Some days we still have trucks picking up at 8 o'clock at night or 9 o'clock at night.
Okay.
I got a question. So you have 2 bays now,
We have 3 bays now.
you're 3.
Actually, there's a couple of bays, Ruben, right? We've got an overhead door here.
And we
we've got
have
overhead
side
door,
bays
overhead
and
door.
there's,
Very inefficient.
there's, I would say there's probably, between all the bays, there's 10 bays around the building all over, but all of them are low space, high space, and it's very hard. Then we have to carry the merchandise internally in the building through small passageways. So we have containers in the front, containers in the back, all over, trying to, you know, to move the goods within the building. And we're just looking to make everything smooth and just on one central receiving area versus all over the building.
I might add too, I don't know if the board has ever seen this by driving by, but because of the finished floor height difference, material goods come out of one side and forklifts travel down the asphalt up onto the ramp into this finished good area of the building. So it's very inefficient. It's not safe to have visitors, traffic, employees mixing with internal movement of goods as well. So
Okay.
I think, you know, where you were heading, it goes to the criteria for approval, you know, in terms of the impacts. And you have an existing proposal that has 3 bays, you're going to 5 bays, you're going to a bigger building. You know, just from our discussions,
Right.
one of the concerns that the board would have is the potential for an increase in the intensity of the operations and an increase in the associated impacts.
I certainly understand the board's concerns, but that's not the case. We're not looking to increase, we're just looking to run a more efficient operation. Right now, it's every shipment that comes in goes through various processes, gets received upstairs, and with the forklift gets taken down to the lower floor. So it takes us much longer time and it takes much more resources to do the same thing. We're looking to streamline the operation.
So you actually have trailers back in other than where the 3
Yes.
docks are? They
Yes.
back in all around
Yeah,
the building right now?
If you pass by South Street now, you'll probably see containers in front of the building. There's loading docks in the front of the building as well.
Okay.
let's highlight for the board where the other docks are.
I'm not,
Because I
where's
think everyone knows
South
there's
Street?
two here.
I don't know where South Street on this side.
South Street is right here.
So if I can go
We've
ahead.
got-
You pass the building, you'll see this container.
Got a series of docks, Ruben, on the north side here at a different elevation.
And they'll be eliminated.
Those will be eliminated, right? So
So the only truck access
It's
will
gonna
be,
Exactly.
consolidated to this area here. Today, somebody have the existing survey? If I can just excuse my pointing, what happened is a concrete pad, the trucks line up in this orientation today, headlights this way. This con pad actually is an encroachment on off this property. Don't know how it got there today, whether it's through Charles's approval or not, but it's there to protect the wear surface. You got trucks idling with the concrete. We're looking to rotate that 90 degrees, keep one loading area consolidated within the warehouse operation, move all of these
and
randomly placed loading docks that worked when the building was an amalgam of an addition. Hey, put a loading door here, and it's all gonna be consolidated to this area. And we think in this configuration right here with 20 feet, 30 and
27, you can get a 53-foot trailer around there without approaching.
this is a WB67, so that's a turning template from CAD.
Okay.
Drivers are usually better than that, just so you know. Well, I see your arc ends here and ends here. This arc would need to continue continue over here because it cuts itself off.
Well,
Same thing in this direction.
Oh, you're talking about this little piece?
Well, where's your turning radius arc? Because I
Right,
see it
right
up
here.
here,
So you see this one field now?
it blends into that edge of the line. So what we're really saying is, yeah, that truck's gonna have to hold that, call it east edge of pavement to swing this. Now, I will indicate, these are turning templates from a CAD program. Drivers usually are better than this, okay? However, if we needed an extra 2 feet of pavement, well, I can certainly say it's better than what's there today. We think it'll work if there's a matter of 4, 6 feet of pavement. Anything that, so stormwater, right? So if anything we do here, it's a redevelopment project. So another benefit that's gonna happen through something like this is going to be inclusion of some stormwater management that didn't exist today. If it comes down to us having to add a couple hundred square feet to make the board feel comfortable with turning maneuvers, that's very attainable for us. But generally speaking, it will be a one-directional flow, so we'll be signage bringing trucks in this way. It clearly cannot handle two-directional flow. The trucks will pull in, and they will back in, and they will leave out of South Street in a logical fashion.
Because I do see you could gain turning radius and you would be in compliance if there were 4 bays there.
We don't disagree that truncating a dock would
Eliminate.
the need for two of the 3 or 2 of the 5 variances. But I just want to point out to the board, it isn't 2 docks being replaced with 5. Ruben, I don't have a physical count, but I do know that there's probably,
And
it's probably less
Ruben,
total docks.
you had said your trucks are between 5 and 20 a day.
Yes.
Why such a range? Why such a
I
large
mean, we
range?
do get deliveries and deliveries come from our vendors and sometimes they decide to, on Tuesday, they decide to all of them deliver and then Wednesday it's a slower day and vice versa. I mean, there's busy seasons, there's slower seasons, I just gave you a real broad spectrum. But,
So to keep this within a non-conforming use, we could actually limit the number of trucks and you'd be amiable to saying only 5 trucks or 10 trucks or 20 trucks a day.
certainly that's what the board decides, but, we're just presenting the way we feel our business would, would operate most efficient. And of course, it's up to the board, to review our application and decide.
What is the turnaround on, once they back up to the dock and unload? What's the turnaround?
It usually doesn't take us long to unload, depending on the commodity that comes in. Some commodities come in on a good pelletized nicely, and it's easy to take them off. Some commodities come in on, floor loaded, and it takes 5 hours and sometimes 10 hours to unload.
And what's okay, so you have trailers coming in. What's going out?
Also trailers,
Trailers. So
plus UPS, FedEx, USPS.
okay, so all of that has to be included in your truck traffic.
Of course,
UPS, FedEx.
when I
So
say
you're
to-
telling me completely with trailers delivering,
Yes.
trailers going out, FedEx, UPS, DHL,
that's what I said.
only 5 to 20?
Those are usually one a day though, FedEx and UPS.
We get
Right.
two, we get 2 UPS trailers a day out. We get 1 FedEx truck out and 1 USPS truck out. That's generally, plus the trailers that leave, that we fill up trailers.
Okay, so if we go beyond just, and I think we do, and Paul, we have to discuss this, I think this goes beyond just a side lot and a parking. I think this goes to coverage. I think this goes to use. So we'd have to get a better handle on what your volume is, what your in and out truck volume is.
I can certainly give the board a better census of, what goes on, or, by next board meeting or whatever. The next 10 days, I can give you a better census and average daily. This is just, off my head estimate.
Yeah.
Okay, no, we understand that. So by increasing the building size, you're not going to increase your business, your business potential, the volume that you do.
We don't anticipate increasing. We anticipate a smoother operation. Much faster in and out. Faster unloading, faster loading.
and I'll just say, you know, if and when you get to the planning board, it's going to be the same question. You know, and it's really a matter of what do you plan on for the future for your business? Because now would be the time to talk about that. You know, if you want to grow, then the boards, these guys, for purposes of an area variance in terms of looking at the potential impacts, and the same for the planning board for evaluation of a special use permit. You really need to know what is your baseline and what is your ultimate goal. And do your hours change? For example, are you looking at, you know, 24/7 operations at some point in the future? That kind of thing.
Second
I think-
shift, you know,
I certainly understand that and I understand their concern. That's not in our plans. We're looking to run a more efficient operation.
I- I
We're
hear
looking to
that.
cut back on hours, not increase hours. That's what we look at it. We don't want to be there 8, 9 o'clock and sometimes even later to unload trailers.
Yeah.
okay. Does any member of the board have any questions, comments, concerns for the applicant? All right.
I have one. I'd like to know the last building on the right-hand side, the red building that was put in there. I'd like to know the building date of that building.
Can you, the only red I have.
The check one, the upper loading dock that's gonna get
This is an upper loading dock.
right there. Stop right there. That red building was added.
No, this is a gap. There is no building right here today. It's gonna get deconstructed.
Do- Do you-
There's a gap in the building right here. Yep.
Yeah.
So there's nothing there.
So do you have a
until you get
timeline?
Squared up.
You said there's multiple levels. Do you have a timeline for when all of those were put in?
Oh, so the best I can do,
We can certainly provide. it.
Google Earth. Google Earth.
No,
you
we
can go
have,
back.
we certainly have a timeline, each building. We have a timeline, each building when it was constructed. I can provide that to the board.
No, he means.
Thank you. Yeah,
Yeah,
thank you. That's
yeah,
what I
no, no,
like. that's-
Oh, you mean the phasing plan?
Yeah.
No, I like, it. no.
The existing building. I just want to know when all of the stuff was put in,
We'll
but you
provide
have
to the
that.
board. You'll
Okay.
just
You mean you've got the historical?
Yeah, we got it.
Gotcha. Okay.
I was gonna
That's
say,
what-
one of the things we
that's
can
what
do
I'm-
is help deliver some Google, not Google.
Thank you.
All right. Does any member of the public wish to be heard? All right. If you guys could just step aside for a second so he can come up.
Only you.
State your name.
Jimmy Anzalone. I live on South Street as well. I'm really concerned with the numbers they have and them thinking that they're going to get tractor trailers in and out of that driveway. I've used that driveway numerous times long before they've owned it to turn around my truck in there, and it's hard to get out the existing curb cuts right now.
Well, I think maybe you can speak better to this.
Correct. You have to be, in order to get out of there right now, the way it is, you got to be over in the grass. You cannot. It's a double yellow line there.
It's an existing condition. We can widen the radiuses to that those vehicles on the right side of the stripes. That could certainly be.
My next question is truck traffic. The truck traffic has tripled. And these are all out-of-state deliveries. They're not from the area. They don't know who's around, what's around, who to look out for, dogs in the road, kids in the road. Animal, kids don't belong in the road, neither do animals, but they are. And the amount of truck traffic that is upscaled since this place of operation has started is ridiculous. It's a lot. And I have a concern with that as a parent. My next question is, you want to basically double the size of the building.
No, we're at 30,000 square foot.
Okay, so it's pretty close to doubling it than what you have right there. And you said you're going to have fire suppression, the tanks and everything will be underground water storage?
Potentially,
That's a concern I have. I have a concern because that's a big building. Lowe's is a pretty good sized building as well, and they have a very large storage tank for their water. So where are you going to put it? My next question is, that whole back parking lot right there, when Sandy came through, flooded. Propane tanks were floating. The big propane tanks that are in the back of the building, they were floating.
Well, that line
So-
denotes a floodplain, correct?
Oh, it floods. It floods, trust me.
Yeah, this line right here, denotes a flood.
Oh, it floods.
They've considered that.
Sandy came through and that was completely underwater by feet, not by inches. So I have a problem with that. That we're going to allow a building to be built that is in the floodplain when we have documentation that it has flooded. I was actually there when the tanks were floating. So I want you to maybe try and look into that as well. That's an issue. And what's the weight rating of the county road?
Well, that's a traffic study.
Yeah.
And that's
Okay,
not.
further down the
restored.
road. Yeah.
But I am sure that the road is able to
Sure.
handle the capacity of a truck, being that it's a county road and there's certain standards.
There's a
that
lot
the
of
county
heavy
has
trucks that
to-
come in and out of there. Okay.
There's a certain standard that it has to meet, and if it doesn't, it has to be denoted that there's an R rating on the road that it cannot handle X amount of weight per axle. of
And
a-
furthermore, what is their actual use of the building? Are they in the ag district?
Are they in the ag district?
Yes.
They're in the ag
They're in the ag district.
ag zone.
They're zoned ag. And it's a commercial
They're
entity.
exempt Because it was a bottling company,
It's,
then transferred into a economic return for a
Yeah.
light industrial property.
Yep.
Then it turned again
It-
for,
it's actually, it's called a non-conforming pre-existing non-conforming.
Okay.
use.
Can I clarify? It's an allowed use as a warehouse. The size is pre-existing non-conforming. Is that better?
Besides, yeah, I think
The
that's,
coverage
yeah, the warehouse is.
isn't allowed.
The use is
Yeah.
allowed.
But you would also, what other business did you say was in there? There was a construct.
Oh, I'm talking
you
about
said-
before, the solar company. and there was
No,
another-
no. You had said that there's two entities in there now. Was there a construction company and?
Oh, no, the applicant was Maxon Construction, one of the owner's consultants,
Okay,
and then the owner, one of the.
okay,
yeah.
okay. I misunderstood
Yeah,
what you said.
We represent kind of both entities. Yeah. Okay. They weren't tenancies in the building, only one was, sorry.
That's kind of it. The two biggest concerns I had was the truck traffic getting in and out of there. That's just not going to happen. The computers can say what they want. I've been there and I've done it myself. And the flooding, that actually happened. So to put a building in a flood zone that has flooded before, I don't know about that.
Dave, do we have a copy of the existing? Can you send that to me? Thank you. No, I haven't seen this.
Yeah, it came through with the initial August. submission.
We will resend if you didn't get.
Is there any other member of the public wish to be heard? Does any other board member have a comment, question, concern for the applicant?
Hey, guys. Pardon me, gentlemen. I'm a member of the public. I'm on Zoom, sorry.
Okay, no
All
problem.
right,
Do you mind if I have a answer
Oh,
or ask a few questions?
It's your time.
So I'm the direct
State your name,
neighbor.
please.
My name is Peter DiCapua. I reside at 168 South Street directly. I'm a direct neighbor of this building. So I was just hoping I got a couple of things. I'd like to see the renderings. I'd like to see, it says 30,000 square foot. Where's that water runoff going? I know Jimmy just talked about a couple good questions. Black Creek, because of Sandy, twice this year, actually, the creek ran over 30 to 40 yards that creek overran lots and lots of water. Hour of operation I've seen, and I'm the direct neighbor, is between 6 a.m. to 10 p.m. at night. It's not every night, but you know, it went from normal traffic to a warehouse that's not utilized to an Amazon business, you know, or whatever it is. That building is absolutely full of cardboard and paper. It's all over the roads. It's all over the side of the build. It's all over, you know, the parking lot. And I know it's hard to keep a building perfect, but you're going to need a lot of fire suppression in a building with floor to ceiling cardboard.
Can I interrupt? When you say it's all over the roads, all over the side of the building, it's outside?
You know, when it's windy and they have the loading bays open and they have to run forklifts outside because the building is a super goofy footprint. You have, I mean, we all live in the Amazon Prime age, right? We know how many boxes we get now as opposed to we got 5 years ago. You know, not trying to point the, you know, we all need warehouses, guys. I'm not trying to make it a hard sell for these, you know, good neighbors, but there has to be, you know, consideration for where all this, you know, consumable, you know, combustible material is going to go, because it's basically one big, you know, cardboard storage place. You know, where's the water coming off this 30,000 foot new roof going to go? Because obviously it's got to go in the ground. The ground's already saturated. The tanks are flowing. You're going to have to build in a floodplain-ish. The building, I hope it's nice. I haven't seen the renderings yet. I'd love to see them. If we can either move the camera or email them to me, I'd love to see it. The noise of the workers, you know, the forklift driving around. I know when guys work, they listen to music, but when the forklifts are going early and going until late at night, you know, I have a nice little spot. I got chickens and goats and dogs and homeschool my son. You know, now it's going to be a business. So that's fine, as long as the light pollution's reasonable. They have spotlights all around this place. Security is important. You know, are they going to add any trees to the building, any trees to the property to kind of keep the light and the security on their property? How are they going to take care of the water? The road's already been addressed. So 18 wheelers actually go around the property now. Around the whole back of the property, and it's tight. You know, I've been driving equipment my whole life, probably like Jim. It's doable, but it's tight and it's not an ideal solution. That road, you know, that's a lot of weight. What else? Oh yeah, the traffic overall. It basically comes from the thruway, comes down 20, you know, South Street, goes in and goes back the other way. These trucks can't go really down the road because there's not a lot of places, you know, to go. So traffic is easily 4 times what it used to be 6 months ago to a year ago. Yeah, so if we can manage, as long as managing the water, keeping the hours of operation in a tighter window, I'm all for that. But as long as the building looks nice, you know, there's a golf course, it's a farm, it's a nice road. So if we can keep it nice, those are the only real, you know, welcome to the neighborhood. I'm not trying to say don't do this, but it's going to take a good amount of planning to make the building pretty and to manage all that water, security, cardboard, parking, stuff like that. So, and I'd love to see a picture of it. I'm sorry I can't be there. I'm under quarantine for work. So.
Okay, yeah, if you can send the building department your email address, we'll absolutely get the renderings out to you.
What's the best way to do that? What's the contact email for the building department?
Townalloy.com, building department.
And I'm the department director. Just click on my name.
Just Dave Barton.
Thank you.
All right, thank you.
I may respond.
Who said that? Your mouth cover, I couldn't see.
I'm
Okay.
sorry. So first of all, welcome neighbor, and I appreciate the discussion, and exactly that's our point. We feel that, you know, we don't want to be a nuisance to neighbors, and we feel that this whole plan is to get more efficient and to you know, get better hours and, you know, better efficiency, better waste management, everything, in order to redo the electricity. We had issues with the fire department. all these, in order to redo it, we need to redo the entire building. In order to redo the entire building, we have to get rid of all those full of small wings and small roofs and make it into one big flat roof and control the drainage, control everything. And that's why we came up with this concept of, redoing it and making it a nice place for everyone. We want to be part of the road. We want to match the area. We want to match of course, we want to be good neighbors.
Okay, thank you. Okay. Do you, yeah, public comment still.
So again, I would like to, is there any way we can keep the truck traffic to the daytime use and not at night? I mean, again, just like the neighbor that was there, just like the neighbor said there, I have no problem with them operating a business as long as they're conforming to the legal law of our town. I mean, they did it with Stewart's. I would definitely like to see it between daylight hours, during the day, not at night. Because there has been trucks going through there at night. And I get it, things happen. I'm a farm, I totally understand that. But trucks coming late at night, and a lot of them, that would be an issue. If you could somehow remedy that and the floodplain, I just put up a picture on my phone of my property that was flooded almost, I would say probably 200 to 300 feet from the Black Creek this year. So it does flood. You need to keep that in
Excuse me,
mind.
Jimmy, one time.
Sure.
You're a native.
Yeah.
When did you ever see a cop stop a truck and trailer and tell him that he's on a time delay road sensitive? You never did.
Never.
Never. And
Yeah.
the problem is when we discuss 5 trailers, 20 trailers, there's no way for us to police this after the fact.
Right.
So we have to get all the cards on the table to understand the situation.
Sure.
Now, the man sounds like he's very reasonable.
Sure.
So this is where our problems lie. So we try the best to satisfy everybody.
Sure.
Well, Paul, is there any other information you think we need from the applicant?
I think I can follow up, Dave and I can follow up, and I'd like to look at their narrative relative to the standards and make sure they're hitting all the buttons, but we can provide some guidance back to the applicant.
Okay.
If that's all right with the board, based on
Yeah,
your
if you can,
discussions
if you
tonight.
can include me in that, I'd appreciate
Absolutely,
it.
absolutely. We'll run it through you first.
Okay, all right. Chairman, can I address something to a couple of the questions in the audience just to help you? Believe it or not, flood development in the floodplain is allowed. You're absolutely right? Someone would say, well, why would I? But there's ways to do it to mitigate the damages. There's generally 2 ways. They allow you to build in the floodplain as long as your base flood elevation, your finished floor, any new addition, right? The FEMA can't take care of the existing conditions, things that were built within the floodway that are liabilities when these events hit. What they can control is the development of new structures in the floodplain and how to limit that as to not increase the liability of the insurance tickets every time it's a pull, so to speak, on taxpayer dollars or the people that are contributing to the flood insurance program. So you design your finished floor 2 feet above the base flood elevation, or if you can't do that, you have to specially design the building as a floodway. So it actually safely conveys the water through, takes away some of the buoyant forces, and so that's kind of how development in the floodplains. When people do say, I'm concerned about it, the ultimate people to be concerned, unfortunately, are the people choosing to spend the extra construction dollars to make that work. And then, of course, even if it works, you got the risk of the cleanup. So it does, it is a pill to swallow for people to want to do that. Stormwater management, it's an important thing to note. This site has 0 today. So it grew and it grew and it grew way beyond 8 and 10 respectively building and lot coverage. And it grew and grew and grew to the point where I'm sure there's a significant amount of runoff that is not detained and treated per today's standard.
because if the applicant is afforded the ability to advance the process under planning review, it will be subject to New York State regulations for stormwater control. And in this situation, it's called redevelopment. So what we would do with redevelopment is we're required to treat and detain. So what that really means is treat the quality of the water. So if there's oils and stuff, and we kind of treat that first before it flows into rivers and streams, and then we detain it. Detaining it is letting it out no faster than the pre-existing rate, and that's all done through hydrologic studies and structures. But we'll be required to treat and detain 100% of the new impervious, whether it's building or pavement, that goes on the site. It's better than today. And then along for the ride, we're gonna have to treat and detain 25% of the existing. So it will be from an environmental perspective, it'll be better than it was before if they're allowed to touch it. If they aren't allowed to do what they're looking to do, it'll be an existing condition and the runoff will be what it is.
So you're
Unchanged.
saying the retention pond? Ground.
It'll be something. We've got, so again, you know, as we think about.
Not a lot of room there for a retention pond.
We've thought about what we have for solutions. There's a couple of, there's a depression here today not shown. If you look at the grading, there's a small stormwater area. And, you know, as we put together this sketch plan, we thought about ways to do that. Clearly chronologically, no engineering firm goes in at this level and bangs out what the solution is. We make sure we have something, right? We don't want to sell something to a board and then get to the planning stage and have no engineering
come back.
legs to stand on, so to speak. So I just wanted to thank you for the time. I just wanted to comment because there was a couple of concerns of the members here, and that's generally how it's done and handled. Thank you.
Mr. Chairman, can I just build on that just briefly?
Absolutely.
Just, and this is for the public in particular, the point made by the applicant's consultant is important. At this stage, all they're doing is coming in and asking whether they can have those extra couple of bays because they're too close to the side yard. And they're asking for lot coverage, building coverage we're
And we-
talking about potentially.
Right, potentially. We haven't gotten to the building coverage or the lot coverage yet. Right
Right.
now, the only thing in front of us is the side yard, the total, and the parking.
And that's typical of applicants is they'll come to the zoning board and because basically they're asking the zoning board to change the law to allow that structure to be there. And they haven't done a lot of the studies or, more detailed plans, the stormwater plans and that sort of thing. That'll be for the planning board. Just,
And if it can't be done, there's no, even if the board gave us a variance and we got to a planning stage and engineering wise, we
fair
couldn't.
enough.
Let me tell you, the tail will wag the dog if we can't have a stormwater solution that meets the requirement.
Oh,
Right,
okay.
and I'm
I'm
just letting you know
sorry,
that just because this board may or may not do something, doesn't mean that in the end, there's lots of other, like I'll call
Yeah.
teeth in the process that the applicant will still have to navigate.
Change and move around.
Yep.
Yeah, I just want to make sure.
Again, I don't want to deter
Yeah.
you from
Oh, no, I
doing
wanted to give you guys an answer because it's a
Yeah.
concern and we deal with these concerns every day and we'll let you know
Yep.
how.
There is a lot of clarification.
That I
think Bill.
can address.
I'm in the fire service. so I can tell you that.
Okay, so,
There you go.
you guys are good. We're gonna hold the public hearing. We're gonna extend the public hearing to the January meeting. We have some things we need from you, right? I think you have a
Can I
list. You wrote
reiterate
them down?
quickly before we close it down? You want the easement for the sanitary field. The truck volumes more quantified
Mhm.
and the building addition history.
Right?
Yes.
And I'd like to see if you could take off the fifth bay. Give the board concrete why you need the fifth, why you need to not be in conformance.
Right.
Did I miss anything else, Chair?
To the best of my knowledge, no. Okay, all right,
Thank you very much and good evening. Thanks
Thank
for your
you.
time.
Thank you so much.
all right. Minutes to approve. Okay, September 9th. September 9th. Yeah, they were an email. I printed them out and I just don't know what the hell they're doing. Okay, so September, I can speak to. I didn't have an issue with September. Like to entertain a motion to approve the minutes from September 9th.
So moved.
All in favor?
Aye.
All right, October, I can't speak to because I was not here.
Make a motion, we approve?
All right, Paul,
Second.
second by Bill, all in favor?
Aye.
I can't vote. Okay. And you all important, like to entertain a motion to adjourn.
So moved.
Bill, can I get a second?
Yes,
Okay.
yes.
No,
you
no
got that.
second.
Aye.
Merry
All right.
Christmas and Happy New
Thank you
Year.
very much, everyone. Have happy holidays.